Okay, 2024 CR 012097, state this is Brad Chandler System with the lawyers, please state their name. Oh, and I'm sorry. And 2024 CR 2024 CR 012095, 012094, and 012097, state this is Brad Chandler Simpson. Okay, will the lawyers please state their names for the record?
The case is Sandoval and Van Zieven for the state of Texas.
Stephen Gilmore and Tanya Rivera for Mr. Simpson.
Okay, and sir, you are Brad Chandler Simpson?
Yes, sir.
Okay, now, counsel, you found a motion for the production of grand jury evidence pursuant to Article 20.02D Texas Code of Criminal Procedure, which I think has not been updated, but go ahead, counsel, what's your motion?
Well, I wasn't necessarily going to urge it today, but Ms. Sandoval and I have been conferring with respect to that particular request. I'm satisfied with her assertions to me. I think she was just going to put something on the record real quick.
Okay. Now, let me just go ahead and say this. I believe we are talking about, now it's Article 20A.205, petition for disclosure by the defendant if you show a particularized need. And in your motion, you state that you wanted, that your particularized need is to cross-examine and impeach witnesses, to discover prior inconsistent statements, the credibility of the witnesses and recollection of the witnesses. However, I have handed both sides Legate, I think, L-E-G-A-T-E versus State, and it's 52 Southwest 3rd 797. It's out of the Court of Appeals in San Antonio. And I believe that case involved the 290th here in Bexar County with Judge McRae presiding. And in that case, the court stated two things, was that transcripts and the like, just to locate inconsistencies, is not shown, does not show particularized need, number one. And that number two, it appears that Judge McRae in that case reviewed anything that was presented to the grand jury in camera and determined that a particularized need did not exist. And so you said you conferred with the state.
Yes, Judge, and essentially that's what I would have asked for in this case. If any such evidence existed, I expect the court would have conducted an in-camera inspection of such evidence and then determined based on its estimation what of that I would be entitled to receive. However, upon conferring with Ms. Sandoval, I've learned that no such evidence exists. So,
okay. Then what I am going to do is for the state, any evidence that was presented or shown to the grand jurors, you produce it to the court.
Thank you.
And then if there's nothing, there is nothing. And if there is, just present it. So in that respect, the motion for production is granted in court. For the state to produce anything presented to the grand jury for an in-camera review. And again, if you produce nothing, then just because there was nothing, okay?
right.
So that's that on that motion. And are we here for anything else other than just a status hearing?
I would like to set a discovery deadline, some sort of compliance date.
Okay, and state where are you on that?
Judge, I'm expecting another thumb drive of evidence on Thursday morning from the Rangers. They're working on completing their reports still. They have asked for August 1st as a deadline to complete their portion of the evidence. And of course, I've got to, as it comes in, I'm going through and line by line, just the cross-referencing and making sure we actually have everything that the reports mentioned. But they have asked for their agency for August 1st as a deadline to certify the evidence from their agency.
Okay, and then just I was writing, I should have been listening. Which agency are we talking about?
Yes, Judge, the Texas Rangers.
Okay.
And I will just note for the court that the investigation is still ongoing. There have been searches last week and expect them to be next week. So it's an ongoing discovery issue. But I believe that by August 1st, we should, that at least according to the Rangers, they should be able to get the bulk of what has already been done to me in 2 defense.
Okay, and Counsel?
I mean, I was hoping for a sooner date. Also, we don't have SB 111 certification from Olmos Park. The Ranger binders that I have received, those reports reference additional interviews and investigation by Olmos Park separately from the Rangers. I've not received any new reports since I guess what I got in December or January from Olmos Park. I've not received any new body cam, any new audio interviews. So Olmos Park has given us basically nothing for the past 6 months, almost. So I would need discovery compliance from them in addition to the Texas Rangers. And again, I was hoping I would get that maybe within 30 days.
Okay, now is Olmos Park producing their discovery to the Texas Rangers and then it's coming to us from the Texas Rangers, or not to us but to the state, or are they producing it separately?
So Olmos Park has produced what they believe is a final draft of their evidence to me. I don't remember exactly when, but it was a couple of months ago. They have not done an SB 111 certification yet. My plan, honestly, Judge, was to look at what the Rangers have and cross-reference everything and just make sure everything is there, and then work with Olmos Park to get that certification done along the same timeline as the Rangers. It's massive. So
Okay.
we're actively working on that, and that is the goal.
Okay, then both agencies are ordered to comply with your request by August the 1st of 2025. And then in the meantime, produce whatever was shown or transcribed to the grand jury, and just produce it to the court. I'll review it, and then we'll set a hearing, or maybe even August the 1st. If there's anything, I'll let you know.
Thank you, Judge.
Anything else from the state?
Nothing from the
The
state.
defense?
Nothing from the bench, Judge.
Okay, then that closes the record in this case. Everybody's excused.
Thank you.
very
Thank you.
much.